So my production team always surprises me with new gimmicks in the trailer. So hello and welcome. I'm very happy to see all of you here. Very happy New Year to all of you, and thanks for joining. I'm Thorsten Kriening, the publisher of Spacewatch.global, and your facilitator today. Laura contacted me a few months ago and presented her idea of the association and the event series to me, an entire series about space arbitration. And I have to say I was super excited, as that is focus of our work, as you might be know, all through. It's very narrow, of course, and as a common topic for, I would say, a few dozen people. So crazy enough, and we are in easily. So today we welcome you in this group that almost crashed our webinar license. So we had far over 300 plus registration coming in instead of this crazy dozen, which I expected. So chapeau and congratulations to Laura for the first event organized by the Space Arbitration Association on the topic of whether we need our outer space needs arbitration or not. So I will let her introduce the association and the idea behind the conference series, but a word on our Q&A function. So we will have a Q&A session at the end of this talk, so please post all your questions on the Q&A section here on the lower end, as you know, so we take them into account. I also would like to mention that we are recording this session today. And last point before we start, please keep your messages in the chat or in the Q&A to a professional and respectful tone. Otherwise, we have to take actions, and we don't want it. So, Spacewatch Global is a Europe-based online platform for information in and about space and new space activities in a geopolitical context. And I know many of you are already familiar with our website, our bi-weekly and daily newsletters, and the Space Cafe podcasts. Our latest episode features the outstanding Stephen Freeland, who is in the house today, in his very personal conversation with his host, Markus Moslechner. And for all our fans of audio content, we have new episodes in the Space Cafe Radio, Dr. Emma Gatti's top 10 space events in 2021, and a huge number of great reviews. We are also available on all major podcast platforms. Just search for Space Cafe Radio. So we also keep our fan shop open online for you, where you can support us actively to become a space watcher. And if you've missed any of our space cafes, we have an archive available on our website in the event section and on YouTube. So with that, my job is almost done for today, and I'm handing over to your host, to Laura.
Thank you, Thorsten, and hello everybody from me as well, and a happy new year. I'm glad to welcome you to the first event of the Space Arbitration Association, the association that I founded last year, at the end of last year. And that will focus exclusively on dispute resolution in space. So my idea behind this initiative was to create a forum of discussion between the space community and the arbitration community. And so we will organize around 8 conferences over the year, at which we will discuss open issues related to dispute resolution in space. And the next one will take place on 10th of February. So I hope to see you there as well. And I also wanted to mention that many of these conferences will to some extent build one upon the other. And the speakers of today's and the following conferences have been chosen mainly based on their publications on the topics in question. And on our website, we have a list of articles related to space arbitration. And if any of you notice that an article is missing, please let us know, because it's trying to be exhaustive. So before we start with today's topic, I wanted to thank Thorsten as well for hosting our event. And for anyone who's interested in the space industry and is not familiar with his work, his daily newsletters and the Space Cafes really provide a great overview over what's going on in the space sector. So I can highly recommend it. I also wanted to thank Jus Mundi, which provides access to global legal information thanks to a search engine that combines international legal expertise with artificial intelligence, and to the international section of the New York State Bar Association, who are supporting our event. So with this, we are turning to today's topic, and I will first introduce our speakers, each of whom will discuss a different aspect of whether outer space needs arbitration. So first, Frans von der Dank, will speak about the historic development of dispute resolution mechanisms for outer space disputes. Frans is one of the world's leading authorities on space law and policy, and he currently holds the Harvey and Susan Perlman Alumni Ottmar Chair of Space Law at the LLM program on Space, Cyber and Telecommunication Law with the University of Nebraska, Lincoln. He's also director of Black Holes BV Consultancy in Space Law and Policy, based in Leiden in the Netherlands. He has published over 200 articles on issues of space law and policy and is the editor of the renowned series Studies in Space Law, and has given over 400 presentations and taught as a guest professor at over 30 universities worldwide. He has consulted with hundreds of clients all over the world. Second, we have Jan, who is a former dispute resolution associate at Baker McKenzie and at Morrison Foerster with a focus on international arbitration, and probably the lawyer at his age who has published mostly on space arbitration. He's the author of a series of articles on space arbitration and space disputes, and his article, Arbitration and Space Disputes, spent 8 months in Arbitration International's top 5 list of most read articles, 2 of which is the #1. And the Oxford University Press later added his article also to the article collection, The Promise of International Law. Stephen, who will discuss alternate dispute resolution mechanisms for space transactions and space law before domestic courts, is a professor, an emeritus professor at Western Sydney University and a professorial fellow at Bond University. He also holds visiting or adjunct positions at universities in Copenhagen, Vienna, Toulouse, Hong Kong, Montreal, Kuala Lumpur, Vancouver, Mumbai, and London. He is a member of the Australian Space Agency Advisory Board and has advised many governments and industry worldwide on issues relating to national space legislative frameworks and policy. In June 2021, he was appointed by UN COPUOS as vice chair of a 5-year working group on space resources. He is a co-principal of specialized commercial space law firm Azimuth Advisory, a director of the International Institute of Space Law, and a member of the space law committees of both the International Law Association and the International Bar Association. And finally, Stefanie Haeseker will focus on the space industry and arbitration and practice and present the point of view of a user. And she is senior legal counsel at OHB in Germany. Prior to this, she held various positions in the legal department of a global FMCG company for 8 years. And just a quick word also on OHB. OHB is the first listed space and technology group in Germany with around 2,900 employees worldwide and revenues of around 1 billion in 2019. With over 35 years of experience in the development and implementation of innovative space systems and projects, as well as a range of specific aerospace and telematics products, the OHB group has positioned itself excellently and competes internationally. So with this presentation of our great speakers today, we will turn to the first aspect of the topic, which will be presented by Frans. And as I said, he will talk about the historic development of dispute resolution mechanisms for outer space. So Frans, I hand the microphone over to you.
Yeah, thank you very much, Laura. I'll try to share my screen. And having said that, I also want to thank you, Laura and Torsten, for basically, probably for the first time in a serious manner, bringing these two worlds of space law and arbitration together, because so far they have hardly touched. I'm pretty sure that there are very few space lawyers who have dabbled with arbitration so far. And from the other end, I could imagine that our arbitration audience probably, for the most part, has no idea what space law even is about, or probably even that something like that existed. I can't blame them, because only fairly recently it was the Huffington Post that found out that there is something called space law. Though, of course, the next question is, and I only can go into so much detail given the time, that space law, if you ask me what space law really is, it reminds me of a headline of the New York Times of some 10 years ago. The actual headline read, "Wherever you go, the taxman goes," presenting this idea that wherever humans go, the taxman follows to tax them. And I would actually put it to you that this should read wherever you go, the lawyer goes. And this is not really different for outer space as well. So as soon as humans, either themselves or by proxy, undertake activities in outer space, then the law follows into outer space. And that is basically what space law is all about human activities in outer space. So space law started for real when in 1957, this small metal sphere, the Sputnik 1, went up. It gave rise within a year to discussions within the United Nations about what the appropriate legal regime would be for those types of activities. Was this allowed to start with? And then within a couple of more years, the first General Assembly resolution on space posited the first main principles, the legal principles. Of course, a General Assembly resolution is not a binding treaty. It just puts a moral and ethical point on the horizon. It can evolve to become customary international law, and at least it put forward some aspirations in terms of the law of outer space. Then within a number of more years, actually 10 years after Sputnik, we saw the first binding international treaty, which colloquially is known as the Outer Space Treaty. You see also here reflect the full name. It already indicates that it's very broad in terms of what it covers. It talks about the principles. And it is also broad in membership, and that's very important in the international community to realize that not just the United States and the Soviet Union, who of course were the two countries that mattered in the 60s in terms of space, but also China and India and Indonesia and all the other major spacefaring countries in Europe and other parts of the world, they're all signed up to this treaty. So it really provides the legal framework for space activities. Now, when we talk about law applying to space activities, we should realize the peculiarity of these space activities. And historically, it's probably fair to say that there were three main characteristics of space activities, and to a large extent, they still hold. First of all, they need a lot of high-end technology. Second, they need a lot of money. And third, in spite of all the technology and the money thrown at it, things go wrong. Things will go wrong, things have gone wrong, and things will continue to go wrong. So if you look at why should anyone want to spend any money on space, again, historically, there were basically three reasons making it worthwhile. The first one was military. Obviously, a missile and a rocket are sometimes hardly interdistinguishable. A second reason, closely aligned in the context of the Cold War, was that of prestige. Both superpowers wanted to convince the rest of the world that their political system was superior to that of the other, and the space race was a good way of showing that. And the third was, of course, science, finding out more about the universe, where the Earth came from, where life came from, things like that. As a result of these rationales, only states were interested in spending money on space. And as a matter of fact, at the beginning, it was only a handful of states who had the actual wherewithal to do so, which also meant that space law as a regime of law was very much state-oriented, even more so than traditional international law already was. So it's not, states were not only the makers of space law by way of treaties and customary international law, but they were also the breakers of space law in the sense that they were held responsible and liable for any activity in outer space, even if it was actually conducted by the private sector. And this is, of course, very important. Now, this concept of state responsibility and liability gave rise to national space law with the aim, basically, of authorizing private activities for which the state then could be held responsible and liable. If we had more time, we could play fun with flags, but this is kind of the situation today in terms of countries that have a more or less comprehensive space law dealing with private activities in outer space and licensing them. Now, if you then move to the dispute settlement area, as a consequence thereof, the default assumption for any dispute was diplomacy. Remember, it was all about states. So if there was a problem, states tried to solve this with diplomacy. There is no specific dispute settlement provision in any of the space treaty, with one exception to which I will come shortly. There is only reference to could be made to state exclusive mechanisms such as the International Court of Justice, which was already there. If a dispute related to telecommunications issue, you could perhaps use the ITU. Recently, we see a lot of trade in services globally where you might involve the WTO. And then in some cases, there were national dispute settlement systems as appropriate. Laura, you are muted. Yeah.
Have any of these national dispute resolution systems been used to resolve disputes in space?
Not really. I mean, we've seen a couple of disputes in the US, but that was basically focused on contracts where you had a launch provider for many millions of dollars launching a satellite on behalf of a satellite operator, and then something went wrong with the launch, and the satellite operator wanted to be reimbursed for the loss of the satellite, or wanted to be given another free opportunity to launch the next satellite. But those were basically contractual disputes. In terms of liability, for example, there has not been really anything going on, and I'm only aware of a handful of other idiosyncratic national court disputes or arbitration disputes, which somehow have to do with space law, but usually more like in an indirect fashion, like relating to the intellectual property rights over Earth observation data, rather than the space operations themselves. So I mentioned there was only one exception, and that is the Liability Convention, a follow-up convention to the Outer Space Treaty, which again still requires, as a first stage of solving any dispute, go to diplomacy. Let the states try to decide the dispute in a diplomatic manner. Only when the dispute is not settled within a year, the convention provides for the possibility for states, again for states, to call for the establishment of a claims commission, which is what I would call quasi-arbitration. You have these mechanisms in arbitration whereby a state cannot obstruct the establishment of the commission or the arbitration. The problem is, however, here, and that's why it's quasi-arbitration, is that the award, contrary to real arbitration, is only binding if all states concerned have in advance so agreed, and otherwise it remains a mere recommendation. So that's why I would call this quasi-arbitration.
And Frans, apologies for interrupting again, but could you tell us a little bit about whether this has actually been used in practice?
Well, even that is, thank you for that question, even that is a question of semantics to a certain extent. There has been, the major dispute in international space law has been in 1978, when the Cosmos 954, a Soviet satellite, nuclear powered, fragmented, broke down over Canada and dispersed its fragments over a large part of Canadian territory. Canada issued a claim against the Soviet Union for damages, originally of more than 9 million Canadian dollars. And ultimately, the claim was solved by diplomacy. In the statement of settlement, there was no reference to the Liability Convention. So on the one hand, you could argue it has not been involved. It has not been formally brought into operation. On the other hand, the Canadian claim did refer to the Liability Convention as a kind of a stick behind the door in case the Soviet Union would not be forthcoming with any compensation. It was solved at the level of diplomacy, and diplomacy, as you see on this slide, is also mentioned in the Liability Convention. So you could also argue that the Liability Convention was effectively put into operation, but only as to the first part, the diplomacy. There never was a claims commission, because ultimately the Soviet Union offered to pay something like $3 million. That's basically as far as space disputes went. But then the whole situation changed, and we saw a major paradigm change in space law initiated somewhere in the 1980s probably, and up till today moving ahead. First of all, we saw more and more states involved, not just the two big superpowers and their allies, but a lot of other states from all parts of the world. But even more importantly, we saw that what I would call space activities became more practicalized, meaning that they were giving rise to very practical, down-to-earth applications, like satellite communications, telephone calls, satellite Earth observation for all sorts of practical uses, satellite navigation, and all these pragmatic applications brought the potential for making money with them. And of course, if money is at stake, you will see the private sector becoming interested and then involved. And the main question then, of course, becomes, in view of the state-oriented character of space law, how should this private sector be made to fit into the regime, which also plays into the dispute settlement regime. So on the one hand, you want to make sure that also the private sector complies with whatever the rules are at the international level, and bind them through national law. On the other hand, once you are in agreement that the private sector as such can contribute to space activities and the benefits of space for humankind, then you should also honor their legitimate interests and make sure that they are taken into account and not crushed between the interests of the states. And this is, of course, where disputes may arise. The main answer still is so far that the Outer Space Treaty, as I briefly discussed, does provide for a legal structure guiding how this should be changed. Outer space is free for states, and the states can decide whether they want to allow their private sector to benefit from those freedoms as well. If they don't, then the private sector cannot go anywhere. Private sectors are only allowed within the context of states, and so far that has still dictated any effort to settle disputes, because even if actually a private sector entity is at stake, effectively you will see a tendency for the states to again use diplomacy if possible to solve the issue. The Claims Commission, for example, doesn't allow direct access to private operators. It's still something for states as a tool to solve disputes. Now, that's also where the PCA, the Permanent Court of Arbitration, came in a little over a decade ago when they developed their optional rules for outer space. We might discuss that in greater detail, but of course, for the first time, it offers the possibility for private sector entities on a par with states to get involved into, at the highest level, into solving a dispute and defending their own direct interest. It allows for maximum flexibilities for parties to the dispute, which is, of course, a general characteristic of arbitration. It doesn't dictate what the dispute is about. If parties want to use this rule, then that's okay. The laws that are applicable depend upon the parties. There's a lot of possibility in varying the size of the tribunal, again, as the parties want. Of course, a larger tribunal costs more money, but it also offers more expertise and perhaps a more balanced approach. There's the possibility to use expert witnesses. And of course, most importantly, it does ultimately lead to a binding legal settlement.
And Frans, have these rules been used? So what is the status quo of these rules, and what do you think is the role in the future? Do you think they are sufficient in terms of?
I think they have not been used yet, and that still goes, or I'm pretty sure they have not been used yet, and I think that goes back. Steve, you're nodding. Are you aware of anything different? And I think that goes back to what I said before, that the general overarching tendency in the space world is still to use the states and to have the states pick up these disputes for all sorts of also security related reasons, etc., etc. But there's something more to it probably, and that has to do with the fact that if you are a company in space, so far you are basically a very large company, and there are not too many of those anyway, which means that they are careful not to antagonize potential partners, whether they are states or other companies, by going to court or by going to arbitration, but they try to solve any dispute behind the scenes. Now, to answer the last part of your question, I think that's changing. If you see new space, you see all these startup companies, these news companies, who have fairly little to lose often. And I'm therefore quite convinced that within the next 5 years, so to speak, we will see the first private parties grabbing these optional rules as their best chance to win a dispute or to settle a dispute to their own liking. Of course, it's all crystal ball watching. but I'm willing to put a bottle of wine on that if we take the 5-year limit. I will stop there and allow for any further questions, or if you want to move on to the next speaker. Thank you very much.
Thank you very much, Frans. We have received the first questions in the Q&A section, but I suggest that we continue with the presentations and we will answer these questions at the end. So we will now turn to Jan, who will discuss the specificities of space disputes and the role arbitration can play with regard to them. So Jan, the floor is yours.
Thank you very much, Laura, and thank you very much for having me. Well, does outer space need arbitration? If you would pose that question to Time Magazine's Person of the Year 2021, Elon Musk, then I think there is a chance that the answer would be no. Because during a conference talk in September last year, Mr. Musk said about SpaceX's competitor, Blue Origin, quote, "You cannot sue your way to the moon, no matter how good your lawyers are," unquote. So at least according to Mr. Musk, if your goal is to build a spacecraft that can get you to the moon, arbitration might only be of little help to you. But all jokes aside, if you want to answer the question if outer space needs arbitration, then you really have to distinguish between two types of space-related disputes, space disputes proper on the one hand and space industry disputes on the other. Now, space disputes proper to me are disputes concerning space law, just as the one we just heard about from Professor van der Donk, and activities in outer space, such as, for example, disputes over satellite collisions or disputes over resources in outer space. Now you can distinguish these disputes from disputes in the space industry, and these are contractual and investment disputes between players in the space industry that basically cover the whole life cycle of building, launching, and operating spacecraft. Now, do space disputes proper and space industry disputes need arbitration? For space disputes proper, I would say they will definitely benefit from arbitration as a means of dispute resolution. However, before arbitration, I think outer space activities, like in my opinion and what I hear from people in the industry, are currently more in need of more specific laws and rules. First, we just heard that the space treaties are 50 years old and from a different era of space exploration. So there is a need for loose rules to cover what is currently taking place in outer space with private companies. And once these rules are in place, I believe that there is a great benefit from having disputes resolved through arbitration. Now the situation is very different in space industry arbitrations or space industry disputes. Here arbitration is already a reality today, and I think international arbitration can really play to its strengths here. And there are 3 examples for this that I would like to talk about. Number 1, the need for a neutral forum. Secondly, the need for expertise on the tribunal, and thirdly, confidentiality. Now, on the need for a neutral forum, often in space industry disputes, you have parties from different jurisdictions where it makes sense to have the arbitration seated in a neutral forum. On other occasions, you have a private company on one side of the dispute and a state on the other. And as we just heard, satellites and rockets are dual-use goods. There is a civil and a commercial use for them, obviously, but they're also powerful strategic military assets. And there is a history of states priding themselves with mastering and using the technology. So space industry disputes can be very political. And in that political environment, your chances as a private company against that state and that state's courts may be limited, depending on the state in question, of course. But arbitration really gives parties the opportunity to neutralize that political element and have the dispute resolved in a neutral forum. Now, on the expertise front, space industry disputes can involve very technical issues. they, although some of them are based in contracts, they can involve legal issues beyond the realm of contracts. For example, export control regulations. For those of you with a background in arbitration, you know this by heart. You can pick your arbitrator in arbitration. So that really gives you the opportunity to pick an arbitrator with the relevant expertise, either on the technical front or on the legal front. Although in practice you might also have the effect in space industry arbitration that the parties sort of want to outperform each other by the appointment of very well-known arbitrators. So regardless if that individual has a track record in space industry arbitrations or great knowledge of how a satellite or rocket works, sometimes you see that if the claimant has appointed a very well-known arbitrator, respondents sort of feel like that needs to be counted by appointing an even bigger name if that's at all possible. But that's a strategic decision depending on the case and on the client. Now, finally, on confidentiality, the space industry is historically a small and a secretive industry. So that's the reason why you often find confidentiality clauses in space industry contracts. However, if you have a dispute and that dispute ends up before a state court and gets discussed, there is a risk in that your proprietary or delicate information will be discussed at a public hearing and thereby also become public. And arbitration gives parties the opportunity to sort of carry over from the confidentiality from the contract into the arbitral process if the arbitration is seated in a jurisdiction where the arbitration is confidential from the outset, or if the parties have chosen arbitration rules of an institution where the arbitration is confidential in its entirety, or covers the documents produced in the arbitration, or if the parties have reached an individual agreement on confidentiality. And that works very well for the space industry. You can already see it by the fact that there's usually very little information on space industry disputes when you're not involved. That might also have to do with the fact that the industry is not very litigious and prefers to settle disputes as quickly as possible. But apart from that, where disputes do end up in arbitration, there's usually very little information available. Maybe you get a general description of the dispute in a press release, maybe one or two sentences as explanation in the balance sheet of a space company, but there are very few space arbitration awards available. The only chance really, if you're not involved as counsel or arbitrator to get your hands on a space industry arbitration award is when that award gets challenged or enforced and then is handed in as exhibit in the court proceedings. Now that might change with new market entries in the space industry. At the beginning, I mentioned that Elon Musk quote on Jeff Bezos's space company Blue Origin. For those of you who don't know, just a few hours after Mr. Musk made that comment, Amazon, which as you well know was also founded by Mr. Bezos and also builds a mega constellation of internet beaming satellites, just like SpaceX with Starlink. Amazon sent a 13-page list of SpaceX lawsuits to the tech news website The Verge, just to show that SpaceX is at least as litigious as Blue Origin. And that to me looked a bit like maybe new space has a different understanding of what things might be better left unsaid. So perhaps we'll hear more on space industry disputes in the future. We'll have to wait and see. So in a nutshell, I would say outer space activities will benefit from arbitration, but are in need of more specific rules for the wave of private enterprises first. And for space industry disputes, arbitration is already a reality and working very well today. Thank you very much.
Thank you, Jan. For those who are not familiar with Jan's articles, he wrote an article with the title Per Arbitrum ad Astra. So maybe Elon Musk was also challenging you. You should talk to him at some point about
I
this.
would be honored if he was, yeah.
But for those in the audience who are not familiar with the space industry as much, could you maybe give an example of a dispute? Like what would a space dispute look like a typical dispute?
Absolutely. Well, as I said, space industry disputes are often contractual disputes, and although they're rooted in contracts, they can revolve around legal issues beyond the realm of contracts, such as export control regulations. So, a great example for that would be the ICC arbitration ABS versus KT, in which the tribunal ultimately had to decide if title for the satellite KoreaSat-3 had, and KoreaSat-3 was a satellite that was already in orbit. And the tribunal had to decide if title for the satellite had passed from sellers KT to buyers ABS. So ABS had bought the satellite from KT, and KT had originally purchased the satellite from the US company Lockheed Martin. And 2 years after the satellite purchase was concluded and fulfilled, there were media reports in South Korea saying that KT had sold the satellite for too low a price, which led the Korean Ministry of Science declare the satellite sale and purchase null and void, as it allegedly violated Korean export control regulations. Because, and that part was undisputed, the parties had not obtained a Korean export control permit. So the parties had obtained a US export control permit, but not a Korean export control permit. So the tribunal ultimately had to decide if the satellite sale was a US export and therefore subject to US export control regulations, or Korean export and therefore subject to Korean export control regulations. And for those of you who don't know the case, the twist in the story was that the Korean Ministry of Science is not the competent Korean ministry to issue and monitor export control permits. Actually, the competent Korean ministry stay completely silent on the matter. So actually, the case is also a great example of how politics can come into play in space industry disputes. So it's a good example for politics in space industry disputes, and even though it's a contractual dispute, it can revolve around legal issues beyond the realm of contract, because on the face of it, the dispute looked like a contractual one, but at the heart of it really was the question, which export control regulations apply.
Thank you. And I think Stefanie will also tell us a little bit more about this, but do you think there are other unique characteristics of space contracts that are different from other contracts?
Absolutely. I mean, I don't want to preempt anything that Stefanie will say, but like in general terms, I would say often unique characteristics in space industry contracts really come down to the unique environment that the industry is operating in. Outer space is a very harsh environment. Space is hard, as they say. So there's very little opportunity in testing in a representative environment, very little room for error, very little room for remedying a deficient performance. And very often you have a binary outcome. Either it works or it doesn't work. And then the question really is, whose risk is it that it doesn't work? And the party whose risk it is then has to decide if it wants to take that risk or cover it with an insurance. So, for example, if you know nothing about launch services agreement, then maybe you would think that the launcher fulfills its obligations by inserting the payload into the correct orbit. But often in launch services agreements, you find clauses that the launcher fulfills its obligations with the launch of the launch vehicle, and launch, for example, being defined as first stage engine ignition and liftoff. What happens if something goes wrong on ascent and the payloads end up getting destroyed or inserted in the wrong orbit? Well, doesn't affect the fact that the launcher already fulfilled its obligations under the contract. If the satellite operator does not want to take that risk, if the payload is too valuable, then that can be covered with an insurance. So if speaking from experience, if you look at these contracts with fresh eyes, some of the clauses may seem counterintuitive, but a lot of it really comes down to the unique environment that the industry is operating in.
Thank you. And you also mentioned that there's a lack of substantive rules. So could you maybe tell us a little bit more about which rules you mean by that and what the current developments are in that area?
Sure. Well, I mentioned two examples: space traffic management and resources in outer space. Space traffic management probably being the most urgent one. Yeah, it's. I think there's a strong sense in the space community that it would be desirable to have a multilateral agreement on rules for right of way in orbit. The number of satellites is increasing in orbit, will increase even more drastically in the future, and yet we have no international rules for right of way in orbit. I recently read a quote saying that the regulatory framework for right of way in orbit is please don't crash your satellite, and really please don't crash it into somebody else. So if that's a legal framework, and you look at roughly 3,000 active satellites in orbit, about 3,000 inactive ones, then it's obvious that this is a problem. Will get even more problematic if you count in the planned mega constellations. I mean, SpaceX alone plans to deploy 42,000 Starlink satellites, and that's only SpaceX. OneWeb deploys its own mega constellation. Amazon wants its own mega constellation. So it will get even more crowded in the future. Do I see a trajectory for the implementation of a multilateral agreement on right of way? Not really. What I do see, though, are bilateral agreements between satellite operators. For example, since March last year, there is an agreement between NASA and SpaceX, whereby SpaceX agreed to move its satellites should they come close to a NASA spacecraft. But those bilateral agreements are obviously just a workaround for the fact that we don't have a multilateral agreement. So in that regard, the legal framework is lagging behind of what is already taking place in orbit.
Maybe based on recent events, SpaceX also needs a similar agreement with the Chinese.
Maybe. Well, I'm sure SpaceX has its own take on the matter, and maybe they will say that they very often have to move their Starlink satellites around the debris created by Chinese ASAT tests. But that's again that's probably politics. But you're absolutely right. Yeah.
So thank you, Jan. And with this, we will turn to Stephen, who will talk to us about alternate dispute resolution mechanisms for space transactions and space law before domestic courts. I think this is partly answering one of the questions I've seen, but we will see afterwards in the Q&A session. So, thank you, Stephen.
Thank you. Oh, thank you so much, Laura, and thank you, everybody, Torsten and all of the sponsors for inviting me, and also thanks to Frans and Jan for doing all the hard yards and making my life easier. In fact, you've probably covered a lot of what I planned to say, and I hope I don't do the same for Stefanie. But it's been a fantastic discussion so far. So I'm conscious that I'm talking to a lot of people who love arbitration. So I don't want to be the Grinch that stole Christmas, so to speak, by saying, you know, thanks, but no thanks. So my take on it is there is a role for arbitration in space disputes, like there is a role for a whole range of other mechanisms. We've already heard space is hard, space is complex, there are many actors, many different types of activities, therefore many potential disputes. But there are some unique regulatory aspects to space, both from an international perspective, and Frans has talked about some of them, and in terms of contractual and commercial arrangements, and Jan has spoken about some of them as well, and I perhaps might want to build on that. I also make the point that space law, as has been developed, both at international level and at the commercial level by way of the practices that Jan spoke about and I'll build upon, have two goals. Obviously, if there is a dispute, to find ways to resolve. But before that, you'll see that at international space law, in some of the provisions, and in terms of the practices in commercial space law, a lot of the intention is to stop the dispute from happening in the first place by already, if you like, having predetermined agreements or arrangements or provisions that essentially resolve the issue so that it wouldn't be further litigated. That's certainly the theory. I agree with both Frans and Jan that as more and more actors and more activities and more things happen and the potential for disputes gets bigger and bigger, that we will see an increase in the formal dispute resolution mechanisms, even at a state-to-state level, although I think, as we all know, states are reticent to take formal action. It's a very big step and they much prefer the diplomacy route. But I think even that liability convention that Frans referred to, I think it will come into its own. You know, in the past, people have said, oh, the liability convention has never been invoked, or perhaps it's been invoked, as Frans said, you know, in Canada, you know, in the one situation, and therefore it's not really a stick to hold over us. I suspect things might change at that level. But more importantly, as we get a greater diversity of the actors, we're going to get many, increasingly more non-governmental actors who don't have access to those mechanisms at the treaty level, but will be looking for dispute resolution mechanisms at other levels. So let me quickly share my screen. Bear with me. This is always the hardest part of any presentation. Okay, you can see my screen. So the issues that I want to cover very briefly are set out on this, and this is the only slide I've got of substance, so I'll leave this one on. We've already heard about the growth of space activities. There's a huge increase in activities. There's a huge increase in debris as a result of those activities, many hundreds of millions of pieces of debris. There's a huge increase in the number of space objects. And, you know, if you look at the projections that Jan referred to and other projections, we're going to have exponential growth, many multiples of the numbers of space objects that have been launched since Sputnik. And I'm a Sputnik baby, so I know how many years that I was born in that year. I know how many years it's been. And in that period, we've probably launched there or thereabouts about 12,000 objects into space. We have many hundreds of millions of pieces of debris as a result. But if the well-known, well-publicized plans of just the companies that Jan mentioned and other countries like China, and we've just seen staggeringly an application made by Rwanda for the ITU for frequency of 320,000 new space objects. If we see those sorts of plans come to fruition, then many multiples of the numbers of space objects will go in space. And clearly that has all sorts of implications for things going wrong, given that space is hard. In terms of the factors and that the stakeholders, well, as Frans has said, it used to be 1 or 2 or 3 states. Now there are many states engaged in space activities. The latest guesstimate is about 80 or so countries have some form of sovereign space capability, albeit of course at different levels. But there are many other actors. There are international intergovernmental organizations. There are a huge and growing number of non-governmental entities, commercial actors, research companies, etc. The global space economy is growing exponentially. It was one of the very few industries that continued to grow even through the darkest times of COVID. When the global economy was retracting, The space economy was still growing and continues to grow at levels far beyond the growth of the broader world economy. So because there are many different types of actors, there are many, many different types of disputes that will arise. The traditional, as Frans said, disputes that were envisaged by the treaties and countenanced by those treaties are the state-to-state disputes. But you will often have relationships between states and commercial entities. So you might have disputes from state to commercial entity, from government to private. You might have disputes involving intergovernmental organizations. You might, of course, have private to private and many variations on a theme. The number of disputes and the types of disputes call for a variety of dispute resolution mechanisms. There is, in my opinion, at least, no one size fits all. Arbitration has a role, but there are other ways to resolve. As I mentioned, and as Frans has already pointed to, the treaty system we have has dispute resolution mechanisms in terms of under the Outer Space Treaty with reference to the Charter, peaceful settlement of disputes, and then we have under the Liability Convention, the Claims Commission and diplomacy under the Moon Agreement, we have peaceful settlement of disputes, but we also have those other provisions that, as I say, seek to resolve the issue before the dispute can arise. So we have a non-appropriation clause, which was there. One of the most fundamental issues in international space law was there to say, well, states cannot claim territory. So we can never have territorial type disputes over space. We have international responsibility. It's clear that a state has responsibility under the space law for national activities, even those of non-governmental actors. So it's clear where responsibility lies. We have a liability regime that says in certain circumstances, there's a fault regime to be determined either by negotiation or through a claims commission. In other circumstances, there's an absolute liability regime. So again, resolving the issue through the provisions. And so the whole idea of space at that international level was really to foster cooperation and peaceful activities. We all understand space is far more complex than that, but that was the driving force in that interesting geopolitical time of the Cold War. Ironically, the treaties are framed around cooperation and peace, and there's a whole PhD to be written about that dichotomy at some stage. In the commercial sector, Jan has already mentioned that space contracts are unique. One of the things I hear often when I hear lawyers who perhaps haven't had space experience is, don't worry, we'll just take off our standard procurement agreement, we'll take up our standard sale and purchase agreement, whatever, and for truck or computer system, we'll white it out and we'll put space satellite or system, and we're okay because things must be the same. As Jan has already pointed out, things are very, very different in commercial space law. Jan's already said it's more about a management of risk than it is trying to push risk onto the other side. Typically, for example, delivery of satellites, you won't have warranties about this satellite will be, we warrant that our satellite will be able to do certain things. Occasionally you might, but typically you don't, because much of the commercial aspects of space are driven by risk management, and therefore insurance and space insurance plays an incredibly important part. So that minimizes, to a certain degree, contractual disputes. But of course, disputes might arise. Another factor that must be mentioned is this, again, relatively unique feature of commercial space law, where you will find in most commercial contracts a notion of cross waivers of liability. So typically, if I want to buy your satellite, or if I want to buy a launch from you or whatever, typically in that agreement, we will both, in some way, shape, or form, agree to waive our rights to sue each other under that contract. And depending on the circumstances, it goes further than that, that we will guarantee that all of our contractors and agents will agree that they won't sue you, and likewise, it'll be the same. So these cross waivers in international commercial space law, again, minimize disputes, but they're not comprehensive. Of course, disputes will arise. But really what I'm trying to say is that commercial space, and indeed international space, is unique, and you really need to sort of understand it. Why do we have cross waivers? Well, it was originally a policy that emerged from the United States, but has become relatively general commercial practice. And the United States government, in the relatively early days of the development of their space industry, took the view that space is hard, things will go wrong. As Jan said, it either works or it doesn't, and quite often it doesn't, particularly in those early days. But if we started having people suing each other all the time, then we wouldn't be developing this industry that offers so much to us. Even in those early days, cross waivers covered issues of negligence. I saw there was a question regarding negligence in the Q&A. Now, it doesn't cover all sorts of aspects, but it's just another tool to, if you like, lessen the degree of disputes. That said, we're going to have more disputes because we are going to have more things going wrong, and we need to call on a whole toolbox of dispute resolution mechanisms depending upon the particular situation, depending upon the parties' expectations, depending on the circumstances, etc. And they include some of it already mentioned, the International Court of Justice. Frans and I have had the pleasure of dealing with many of the ICJ judges because they very graciously judge the Manfred Lachs Moot Court competition that Frans and I have been involved with for our work in the IISL. And we know, Frans, don't we? Those judges would love a case to come to them, a space dispute. They would be so excited about it, right? So the ICJ, a possibility. I can't see it happening for a little while, but one never knows. Of course, there's the Permanent Court of Arbitration, or the ICC, International Commercial Arbitration, or other forms of international arbitration is a possibility. I've seen reference to, in the questions, to investment treaties. There's a possibility of dispute resolution under ICSID conventions, perhaps. There's a possibility under WTO or ITU mechanisms, as Frans mentioned. There's also increasingly the idea of a space court, again mentioned in the Q&A. In Dubai, they've recently established a space court for disputes, and we'll see how that goes. So there's a whole toolbox. Arbitration is part of that, but it's only one part of it. Now, arbitration, as Jan said, is a reality in many arbitration clauses, forgive me, is a reality in many commercial space contracts. But, you know, I have to sort of take issue a little bit with what was said, because that is typical. Arbitration, for all its advantages, and we love it, and again, I don't want to be the Grinch who stole Christmas, but arbitration is expensive. It is time consuming. It takes a lot of management time. It takes your technical expert. Essentially, if you want to engage in arbitration, you have to be prepared to weigh it out, both in terms of time, resources, management time, and money. That works for large companies, perhaps, depending on their ongoing relationship. But in this movement towards new space, we've had reference to new space in terms of really large companies, Amazon and Blue Origin and SpaceX. And of course, they are high profile. But in my country and in many countries, many space actors are much smaller companies doing really innovative things, taking advantage of the miniaturization of technology and being able to be nimble. But frankly, from their perspective, even if an arbitration clause is imposed on them, if they have a contract with a much larger company, it will be not really attractive to them to engage in arbitration if the cost if the time, all of those sorts of issues. Literally yesterday, I was speaking to a company that was exactly in that situation, with a dispute with a much larger company under contract that involved several millions of dollars. But essentially, the company said, well, you know, this just doesn't work for us. We can't do this. It would take all of our effort, and we'd stop, we'd be out of business, because everything would be concentrated on that. And so you're finding now other forms of mechanisms. We're often now inserting in some of those contracts expert determinations, for example, which is, you know, in a sense, a mini arbitration, but, you know, it's a bit different. We're trying to fit the dispute resolution mechanism to the circumstances. So I'll leave it with that, because I know time is moving on, but I hope this has at least helped and added more to the excellent presentations of Frans and Jan. Thanks, Laura, over to you.
Yes, Stephen, just as an arbitration lawyer, I have to say one phrase to defend arbitration. I think arbitration can be as costly and time-consuming as you want it to be, to a certain extent, obviously not completely, but I mean, there are options of reducing the costs and the time it takes. But yes, I have just one question for you, because I think you answered a lot of points during your presentation, but you mentioned that space transactions revolve a lot about the management of risk. So how do you think this fits with a fixed dispute resolution mechanism? How could these two systems interact?
Well, as I said, and as Jan referred to, risk is really, it's really about management of risk. So if you take a typical launch scenario, I want my satellite to be launched on Jan's rocket. I enter in a launch agreement with the conditions that he's imposed on me. I try to negotiate with him. We have fun. We finally get there. There's a risk management, because there's also a satellite manufacturer who's making my satellite. Let's assume it's a geostationary satellite, just to make life a bit easier. So the question is, when does the risk pass? In a sense, if my satellite is being built somewhere else, typically the satellite manufacturer will essentially keep the risk of everything happening until the satellite is delivered to Jan's launch site, is loaded onto the rocket is fueled, everything is double checked. 10-9-8-7-6-5-4-3-2-1, we get to the point of intentional ignition, where somebody presses a button, typically. And at that point, typically, because Jan said risk pass at launch, but if you look at insurance contracts, they have different definitions of launch, which in itself is a bit of a problem. You know, the insurance industry really needs to standardize that. But at some point, the risk will pass from the manufacturer to me. And then, assuming Jan's rocket does what it should do and sends me off, the risk is all mine. So up until the moment of that someone pressing the button, intentional ignition, the manufacturer will typically have pre-launch insurance, because these are expensive things. Many things can go wrong. The risk is with them. It will be agreed as to when the risk passes to me, typically intentional ignition or whatever. And from that moment, I have all the risk. So I need to have launch insurance. And I have to make sure that my launch insurance completely dovetails into the manufacturer's pre-launch insurance, so that there is not one scintilla of time where this is uninsured, if you like, because of course the launch is the most hazardous part of the journey. And so it's really a matter of managing that. You might often find disputes arising between the insurance companies. We had a famous example of, and then I'll stop, Laura, several years ago, I can't remember the date now, there was a quite dramatic explosion of when Sea Launch, which was a launch platform in the high seas, was provided the launch service to a particular satellite, 10-9-8-7-6-5-4-3-2-1, huge explosion. And the question was there a launch? Did that satellite, before it exploded, take 1 millimeter off? Because under the definitions of the insurance policies, the risk would have passed. And the insurance, and so in the end, there was a fight between the insurance companies, not between the satellite owner and the launch provider. So it's really a matter of managing all of that. That said, things often will fall to arbitration in other ways, but you really have to be careful and make sure that you get the right people to advise you as you enter into these arrangements. Thank you, Laura.
Oh, thank you, Stephen. Very interesting. So with this, we will turn to Stefanie and to the point of view of an actual space company, because as I mentioned to her, it's interesting to hear all of the academic perspectives, but it's also good to see what they do in practice and whether arbitration is an option for them, for example, or not. So Stefanie, yeah.
Yeah, thank you, Lara. Thanks for the introduction and thanks for having me. Before I start to give you an idea of the opinion and thoughts from a space industry's perspective, I would like to say a few words about OHB, so the company I work for those people who haven't heard from OHB before. And also knowing something about OHB will help to understand our point of view. So as Laura already mentioned in the introduction, OHB-SE is a space and technology group based in Bremen, so northern Germany, with 40 years of experience now. So OHB is family owned, but a listed company with 2,900 employees at the moment. To this OHB group belong several companies located in the key ESA member states like Italy, Sweden, Belgium, Czech Republic, Austria. So we have different locations in Europe. Within OHB, we are operating in 3 different business units. So our core business and the largest business unit is the business unit Space Systems. So there the focus is on the development, the production, and also the launch of satellites for navigation. For example, the famous Galileo program funded by the European Union. Then for science, we are building satellites, manufacturing satellites for Moon and Mars activities. We are manufacturing communication satellites as well as Earth and weather observation satellites. The second business unit of OHB is operating in is the aerospace business unit, which is focusing on production and development of products for the aerospace industries. OHB is, for example, the largest German supplier of the Ariane program. So, and also OHB is involved in projects for radio telescopes and system antennas. Last but not least, the business unit number 3, which is relatively new. This was founded to say so in 2019 as the business unit Digital. And the business unit Digital focuses on the operation and utilization of satellite data. So OHB is also offering own software solutions for software, hardware, apps, and services. So we are developing ground systems and software solutions as well as IT security solutions. Our key customers are the European Space Agency, so acting on behalf of the European Commission, the German Aerospace Center, as well as the German Federal Ministry of Defense. So saying this, this also explains why arbitration so far did not play an important role for OHB so far. So we are in a very narrow market with key customers in the public sector. The environment is very political. So therefore, arbitration, fortunately, did not play an important role. But I can tell you, as Jan already mentioned, confidentiality plays an important role. I can tell you that in all our contracts we have in the space industry with our partners, there are very extensive dispute resolution clauses included, so that even before entering into arbitration, in the contracts we have, there are mechanisms defined in order to find solutions in case a dispute arises. So ESA, for example, in its GCCs, which are also publicly available, defines that if a dispute arises out of the contract between the parties, each party may refer the dispute to a dispute resolution board. And this dispute resolution board consists of 2 senior representatives from each party and the ESA's industrial ombudsman. So even before entering into arbitration, into a formal process, these disputes which arise out of the contract can be referred to this dispute resolution board. And if then this dispute resolution fails and there's no other arbitration foreseen in the contract with ESA, then any dispute shall be settled in accordance with the rules of the ICC. So as you can see, as an example of the ESA contract, which is, in Europe, our largest customer, arbitration did not play a role so far in practice, but theoretically in the contract it is foreseen to have arbitration. And I can fully confirm what Jan has already said. So far, the traditional space industry is not that litigious, and up to now. But we also believe that this might really change in the near future. The commercialization of space flights, the rapid increase of the number of players in the field, clearly indicate that there will also be an increase in disputes. And I also fully agree with the others, what the others have said, that the disputes in the space industries are different from other disputes. This is because of the technical complexity, of the transformation of international space laws. So as we know, not all countries, Germany, for example, does not yet have a space law. Other countries have one. And it really also depends on the complexity of the on the technical complexity. So, for example, our biggest challenge are always the launch contracts, which Stephen and also Jan already mentioned in their talk. So we fully agree, and I would say yes. Also, from a space industry's perspective, we would need space arbitration due to the reasons I just mentioned, and we also would benefit in the future from clear clauses, from technical expertise of the arbitrators and the tribunal itself, and there are a lot of specialties which need to take into account in space arbitration and space disputes, so that I can tell you from our perspective, we would really say yes to the space arbitration. Yeah.
That's great news for arbitration lawyers, although Stephen is also right, because it seems to be like a last resort option for the space industry, or I guess in general it's always true, nobody wants to go to arbitration. It's I think.
Yeah. Yeah, I think also due to the political environment and the customer structure we have, it is necessary to have something like this in place. Yeah.
And in your experience, if you look at the contracts that you have seen, so would you say there are, or I think you mentioned there are arbitration clauses. Do you know which arbitration rules are usually included in these contracts?
Yeah, so most of the contracts I have seen, they have the ICC arbitration foreseen in the contract. So this is really the vast majority from the contracts in Europe, the ones I've seen. Yeah.
I think this is very interesting because the Permanent Court of Arbitration in The Hague has developed these outer space rules. So I think it's interesting that the space industry still prefers the ICC rules over the PCA rules. Do you have an idea of why that could be the case?
I suspect that perhaps these regulations are not well enough known, even if they are already around for 10 years. So I also asked my colleagues and also my colleagues from other companies. So and they are not, and as I already mentioned, so ESA plays an important role. And in the ESA GCCs, for example, there is ICC arbitration foreseen. But I think really the reason is, from my point of view, the insufficient awareness of these rules, to be very honest. Yeah.
Do you think that to the extent that there will be more disputes and the PCA rules will be better known, this could change?
Yes, I think so. And this, especially for the reasons Jan already mentioned, due to the increase of players in the market, due to the Jeff Bezos, due to the Elon Musk in this world, we will have more disputes, as there's a lot of traffic, and there will be a lot of traffic in space very, very soon. And I guess that also, from my opinion, this will really change in the near future due to the environment we will have soon. Yeah.
Yeah. Thank you, Stefanie. Also very interesting to hear from an actual space company. I think with this we can turn to the Q&A questions, and I'll just take the opportunity to advertise our conference series, because there will be specific conferences on a few of the topics mentioned. For example, we will have one conference on space accidents and tort claims, another one on investment arbitration, and someone asked about the Dubai courts. And during the conference on 10th of February, we will discuss institutions specialized in space disputes, and we will have someone from the Dubai court talk to us about their system. So I think to some extent those will be answered in the future conferences, but we will still address them today, starting with the investor-state disputes in the space industry. And I think this is something that Jan can answer well, if he doesn't mind.
Absolutely. Could you point me to the question? I see that there are...
Yes, so the question is, I was wondering whether the use of investment treaty arbitration could be an option when it comes to the resolution of space disputes related to space exploration by private parties.
Absolutely. It is an option, and as you well know, Laura, there are some examples for that. I mean, the most famous one is probably Divas. Divas is a case which revolved around a lease agreement for satellite capacity on two geostationary satellites, which the state-owned company Antrix, owned by the Indian state, revoked. So the Indian company Divas, which had multiple foreign investors, had no opportunity to provide broadband services in India, and that case is also a great example for politics in space industry disputes. But that resulted in 2 investment arbitrations and 1 commercial arbitrations. I think in all 3, if I remember correctly, in all 3 arbitrations, the claimant won. So there are great examples for how investment arbitration can take place also in the space sector, but you have to appreciate that for investment arbitration you would always need an investment in a host state under an investment treaty, and so the investment treaties in place, I would argue, have states on planet Earth in mind. Space, however, is the province of all mankind. It's not subject to national appropriation by claim of sovereignty. So I think if you look at an investment dispute in space, then you always have to overcome the fact if if it concerns an activity, an actual outer space, how to overcome the fact that there needs to be an investment in a host state on planet Earth. Once you have that, then of course investment arbitration is an option. But you really have to have an investment in a host state on planet Earth, otherwise it doesn't work.
Yes, I think it could be argued that due to the registration obligation and other links, there could be a nexus between an investment in outer space and a host state. But I think this is subject to further discussion. There were a few questions about tort claims in space related to space debris and a possible basis for consent for arbitrating those disputes. And I think Frans or Stephen, maybe if you could say a few words about this.
Okay, Steve, if you allow me to take this one first, and then you can add and correct me. Well, space debris is at least in theory part of the Liability Convention. So if you can, and that's of course the big if you can identify the launching state, which in the Liability Convention is the state liable for damage, if you can identify the launching state when it comes to a piece of space debris crashing into your satellite, or in a bad case, crashing onto Earth, then you're still in business under the Liability Convention, so you probably don't need tort law. However, of course, the Liability Convention is only applicable as between states, and if the victim state or the state to whom the victims belong, for whatever reason, doesn't want to initiate proceedings, then the private victims, the private satellite operator, for example, would be without a remedy. And that's why there might be, in a second instance, a recourse to national tort law. And actually, it's interesting to note that the Liability Convention specifically recognizes that. It doesn't present itself as the exclusive remedy. It does provide, or does reckon with the possibility that a private victim, a private party hurt or harmed by another satellite physically in terms of the Liability Convention can initiate its own proceedings, for example, in the courts or arbitration tribunals of the launching state. And it even stops proceedings to a certain extent in the Liability Convention to give sort of preference to those private proceedings. Having all said that, also in a tort case, you're still stuck with the problem of identifying the guilty party under tort law, because essentially the problem is the same. If the piece of space debris, which incapacitates your satellite in a bad accident, has come from a fragmentation collision 10 years earlier, it is probably maybe not entirely impossible, but at least very unlikely or very difficult to be able to calculate that piece of space debris back to the original collision to find out which private operator under the national tort law that you might wish to use is still liable. So in practice, you're still facing the same hurdle. Steve, over to you.
Oh, thank you, Frans, and absolutely, I completely agree. Just 2 points on that. Firstly, you'll recall I mentioned the cross waiver issues, and so there have been case law in the relatively early days of cross waivers in commercial space, albeit, where the cross waiver was held by the relevant courts in the US. Under that contract, the cross waiver was held to also cover a claim of negligence as between the parties, not on the contract, but as a claim of negligence between the parties, unless it got to the point of what was called gross negligence, which is a concept as everybody knows under US law, but not under Australian law. Things are changing a bit now, but so the cross waiver doesn't necessarily cover claims of negligence, but you'll need to look at the cross waiver and what it says. A relevant comment, but really following up on Frans, is we you know, the international space law regime needs help by looking at domestic law about tort claims and things like that, because under the liability regime that Frans explained to everybody, where there are collisions in space, the resolution is determined by fault. Now, that of course assumes, as Frans said, who the launching states are, what piece of debris or whatever caused the collision, but then you then allocate the liability as between the states on the basis of fault. There's no clarification whatsoever as to what fault means. So you can imagine how difficult sometimes it might be to determine fault, given that, you know, a lot of the information will be confidential, ITAR protected, or whatever. But we need to slowly learn, because as I said, and I think Frans also agreed with this, that the Liability Convention may come into its own a bit more in the future. We don't know, but it's certainly there. We need to understand what fault means. We have some ideas because under the international framework, we now have sets of guidelines about debris mitigation, about sustainability. And if you don't comply with those and implement them into your space law, perhaps fault might be attributable to you, but we still don't know. So we have as much to learn from domestic law on these issues and see whether that then will be applicable in the space environment, which, as we've all agreed, is somewhat unique, but we need guidance. Thanks, Laura.
No, thank you. I think this answers most of the questions. As I mentioned, our next talk will deal extensively with the Dubai courts, so I think we won't dive into this now. So I will hand the microphone over to Thorsten for his closing, and I think with this we will manage to finish on time. Thank you all very much for attending, and to our excellent speakers for their presentations. I'm glad that you agreed to join us today. Have a good day.
Yeah, thank you. Thank you, Laura, and congratulations to this first absolute fantastic event. So before we finish, do not miss the next events of the Space Arbitration Association. As you can see here, and I have seen many of you are already registered for that on the 10th of February. Laura mentioned that. Is there a need for an institution specialized in space disputes? It's available on Eventbrite already. And on the 24th is the next one that we're planning with the association. Is there room for private parties in the international space law? And our space cafes continuing next week. And on Tuesday, I have the great pleasure of talking with our good friend Peter Hulsroy about his new book. And I really can recommend it to you, The Optional Society and the Letter Concerning Inclusion. So we will talk about that. A week later, I will be in Brussels at the EU Space Conference, and we'll have an exciting 33 minutes with one of the people from the Commission, which I'm not announcing yet. Okay, fair point. I don't have a confirmation yet, but that's a minor detail. And then on the 27th, with that, Steve, over to you, to your show, the next Space Law Breakfast. Who can we expect?
Oh, thank you. Yes, I have the pleasure of every 2 months having a discussion with eminent people around the world where we look at space law and how it applies to everyday events. And we've got on the 27th, two amazing people, Guyo Wang from China, who really knows everything there is to know about international law and has many ideas, and Geraldine Go Escola from Singapore, The Hague, who is an expert on technology and space, AI and space. We'll be talking about collisions. Somebody mentioned very recent in our talk today about the Chinese issues with the Starlink satellites. We'll be talking about that. So please, if you have any opportunity, come and join us and bring along your favorite breakfast treat, because we meet in a cafe. This time we'll be in Singapore. Thank you, Thorsten, for allowing me to mention that.
Sure. I mean, it's my pleasure. And hey, it's the same time. We're starting 9:30. Yes, it's hard for the US, but we do it for Asia and for Europe here. All these events are online or going to be online on Eventbrite. And as always, we would like to hear your feedback. So please check in with us on Twitter, on Facebook, or LinkedIn. Don't forget to sign up to our daily bi-weekly newsletter. And if you like to treat yourself with something special, become a space watcher today. Yeah, that helps us a lot. So thank you, Laura, for this great first event. And thank you all your fantastic guests for their inspiring, very deep talks. So we got a lot of very positive feedback already. And yeah, we will continue. I mean, we had a really severe number of people in the house. So that's a great start. So I hope you all will stay safe, stay healthy. Thank you for joining us. Hope to see you next time, next week. In the meantime, visit our website or the website of the Space Arbitration Association. So now follow us on social media. But as I always finish, don't forget, become a space watcher. Thank you very much. Ciao, ciao. Laura, great stuff.